I have had the opportunity to join the committee a number of times and discuss as the committee turned to the option of an operations ordinance and started to work on drafting some language for an operations ordinance and more recently the manure storage ordinance. So I guess just as a background, when we initially addressed this issue to the full board, it was in the context of an application that has been received by the county. The county has adopted a livestock siting ordinance, and that is currently in place. That is the standard ordinance with all of the state requirements. There's nothing exceeding the state restrictions for CAFOs currently in the Bayfield County siting ordinance. So when the committee, having done some of this detailed work and really focused in on some of the issues and concerns of Bayfield County, started to look at options. One option before them was to consider regulation of siting matters in a more restrictive manner than what we already have. Again, what we have right now is the state standards for everything. We are allowed under the siting law at the state level to enact more stringent regulations for siting, but only if the county adopts scientifically defensible findings of fact. So that was one alternative that the committee talked about. Another alternative that the committee talked about was to approach livestock siting again through zoning, which we do not currently do in Bayfield County. We have a permit ordinance. It is not attached to zoning. So we would be allowed to address siting through zoning, by which I mean potentially identifying particular zones in our county where no CAFOs would be allowed or CAFOs of only limited size would be allowed. Again, that would have to be based on some scientifically defensible findings of facts as to why certain CAFOs of a certain size would not be allowed in particular areas. So that was another possibility the committee considered. Ultimately, the path the committee chose was to draft an operations ordinance. As far as I'm aware, there are no other operations ordinances for livestock matters in Wisconsin. It is new ground. It is the authority, however, upon which the committee proceeded is based on a 2012 Wisconsin Supreme Court case, Adams v. Wisconsin Livestock Facility Siting Review Board, wherein the Supreme Court actually found that a town was, which had imposed more restrictive siting requirements, did so incorrectly because they had not adopted more scientifically defensible findings of fact. In making that decision, the Supreme Court said essentially, look, local municipalities aren't left without any ability to regulate. There are state and DNR regulations that are promulgated to address some of these matters. And then there's a footnote, and the footnote, and I'm just going to read a portion because I want you to understand the legal rationale for an operations ordinance. There's a footnote that says, it doesn't make any sense to this dissent to interpret the siting law as prohibiting a political subdivision from granting a permit with otherwise valid conditions regulating the livestock facility, while at the same time interpreting siting laws and validating the permit conditions, yet allowing the political subdivision to impose the same conditions on the operation of the livestock facility and to pursue remedies against a polluting facility. The distinction between livestock facility siting and livestock facility operations may not, quote, make any sense to the dissent, but it surely makes sense to the legislature, given that the entire siting law is premised on that distinction. Thus, the Wisconsin Supreme Court seems to have identified that there is something called livestock siting and something called livestock operations. That's the justification for an operations ordinance. The Supreme Court said in a footnote in this opinion that there's a difference. So what is the difference? I would refer back to that exact quote where the Supreme Court said, look, the dissent may not know, but it must have made sense to the legislature. They promulgated this livestock sighting law. So the committee, I think, has approached the work of saying, okay, if it's something covered by livestock sighting, it's a sighting issue, and we can't regulate it unless we have scientifically defensible findings of fact that are adopted. But we can regulate operations. And so we're trying to walk a line and stay on the side of operations, not sighting. Again, this is pretty new terrain. It doesn't exist anywhere else in Wisconsin at this point. It hasn't been tested. So to the extent that it would hold up in a legal challenge, it's unclear. My advice to the committee that I think they followed to a great extent was to create an ordinance, if they're going to create an operations ordinance, which is what they in fact did, that didn't have a lot of specific requirements that are going to apply to everyone. That somebody could say that's a sighting issue. For example, the quantity of pollutants that could be put into the air. Arguably, if we had, this is the exact limit that we're imposing, and it's below the state mandated level. Somebody could say, you're usurping sighting law. This is a sighting regulation. You can't do that. So the ordinance that you have before you, the operations ordinance, in some ways may seem unsatisfactory because it doesn't have a lot of those real specific details. On the other hand, it allows flexibility for the county board, who under this ordinance would be the entity looking at one of these applications, to investigate the nature of the application, the particulars, where, what, how many, how close is this to wells, how many people live in the area, what are the road conditions, things like that, and to perhaps impose some conditions to say, okay, well, maybe we'll grant your operations permit, but there's some conditions that you're going to have to meet because of where you're locating, what you're locating, and the particulars of your application. I don't know what those conditions are right now. We won't know what those conditions are until we have an application, the board has an application in front of it and desires to put some restrictions, some particular restrictions on an applicant. At that point, the board is going to face the question, whatever the condition you're looking at imposing is, for each condition, asking yourself, is this citing? Because if it's citing, we can't do it unless we adopt scientifically defensible findings of fact in our citing ordinance. So it's going to be sort of a process that will have to be gone through at some point, but the decision and the method adopted by the committee in drafting this ordinance was, let's leave that for an as-applied situation. When we actually have an application for an operations permit in front of us, can look at the details and figure out what is it we really think is necessary in order to protect public health and safety in this situation. Attached to so that's the background of how the operations ordinance was drafted, at least in terms of the legal framework. Attached to it is an application that was also crafted and discussed. The application does request some very specific information of applicants. It doesn't set forth any requirements. It's requesting information. Explain this to us, explain what your plan is, if you don't have a plan for this, why don't you think you need one? And from the information on that application, the board, from that and any other materials presented with the application, the board can hopefully determine what conditions, if any, would be necessary to grant a permit. So that's an initial overview of how we got where we are in terms of this operations ordinance, and hopefully have crafted something that is within the bounds of what we're still allowed to do at a local level.
All right, any questions for Linda at this time? Go ahead, Dee.
I don't know necessarily if it's been answered or not. There's discussion in the application about the animal welfare and about questions like what kind of plans, et cetera, et cetera. Is there something later that we can has the county worked on to recommend or say what size we don't want?
Well, I think animal welfare is arguably one of those topics that's not covered in the citing law. So we would, relying on the Supreme Court, which said, well, the legislature told us what citing is, it's in the citing law, say it's not the citing law, so I guess it's an operation. And the Supreme Court says we can still regulate operation, so we should be able to regulate that. Now, we maybe could have gotten specific with that right now, but again, the approach from the committee was, let's leave it open. We asked the questions, what are your plans? And if, upon reviewing those plans, the board and perhaps working with the consultant to figure out what is appropriate for that type of animal in this environment, the board determines we don't think that's sufficient, the board could come up with a permanent condition to say, this is the size crate that we're going to require you have for every animal, under these circumstances.
There's a chance later, maybe.
No, yeah, that chance still exists. I think that the operations permit actually leaves open, at this point, leaves open the possibility to almost any condition. Now, of course, you're going to face the question when you're posing each condition, is this citing, and can we justify it, with this particular applicant?
Is there any other additional questions for Linda? Go ahead, Mark.
Yeah, I just wanted to thank Linda. I think that as the committee was working to put this ordinance together, I think as Linda mentioned, it's very unique that there's no other ordinance. And I think one of the key aspects of that Linda tried to address is making sure that it was legally defensible. And I think in the reviews that we've had, I think they've come to the conclusion that it is, not to say that it's foolproof, but it is a legally defensible document. I think that the board should be pleased with it.